All right, I'd like to welcome everybody to a legal guide to privacy and data security workshop. My name is Michael Cohen. I'm the other Michael Cohen, just so for those of you that came expecting that you were going to hear from Donald Trump's personal lawyer, that's not me. For clients, I don't have funds set aside for you in case you get into any difficulty. I am the Michael Cohen, who's a principal at Great Plant Moody. I am the primary author of this legal guide to privacy and data security, and I've brought with me, this morning some of the other authors that helped, put the guide together. So the purpose of this morning is really to talk to you about what the guide is, and also to make this as interactive as possible. If you have, questions, please feel free to ask them as we go along. Just a couple of things I wanted to, mention for those that are here in person. We will validate your parking. Make sure before you leave that you have it taken care of at the desk. For those of you who are attorneys, we do have certificates of attendance so that you can pick those up. They're in the corner back there. Please take them so you can get your CLE credit. So we have a large number of people that are online, and for those that are participating via the webinar, please feel free to ask your questions, via the online option, and we'll try to answer those, throughout the program as well. So what are we going to do today? The agenda basically is going to be, to give you a very brief overview of the legal landscape of privacy and data security that we cover in the guide. We're also going to cover what is probably the most significant and noteworthy event that privacy professionals are dealing with right now, and that's this new California Consumer Privacy Act. And then what I thought I'd do, just to make it a little bit more interesting so that you don't have us just droning on and on about, federal and state privacy laws, is to have what I'm calling the Privacy Hall of Fame. So I'm going to introduce some personalities that I think are very important for you to know, and hopefully some of you may recognize them and see why I feel that they're important. So we look at privacy here as a team sport. I am very familiar with the federal and state privacy laws and have certifications from the IAPP, both in United States privacy law and European privacy law, as does Amanda McAllister, who's on our panel. So we really look at this from a very broad level, but as you can imagine, there are laws unique and specific to industries and areas of law, such as healthcare and employment law. And that's why in the guide we tried to cover those particular sections, specifically. So we have on our panel also members of our privacy team from the healthcare practice group, Jesse Berg and Mark Matheson from our employment group. So they're going to be here to answer any, questions that you might have in those specific areas, as well as, talk to you a little bit more about the unique issues that they're dealing with in those, sectors. So why do we do this legal guide to privacy and data security? First of all, I don't know if they're present live or online, but Madeline Harris and Mark Simmer and Charles Schaefer from the Minnesota Department of Economic Development have worked with us for many, many years in putting together these publications that are geared not for lawyers, but really for small and medium-sized businesses, so that you can get a better understanding of what the laws are, so that when you have discussions with your lawyers, you understand what they're talking about. So it doesn't go into a lot of depth. There's not a lot, it's so that you can sit by a fire and have a cup of coffee and enjoy reading about these laws. So we cover the whole landscape, federal, state, as well as global, because I don't think there's a Minnesota company that's so siloed that they don't have some global work, whether they're collecting personal information of European residents or not, they still need to be aware of how those laws apply to their business. So we do cover, global, privacy laws to some degree in the guide. And we include at the end of the guide best practices. So the things that you as a business should consider, implementing to make sure that you're in compliance. The one thing I will say that as lawyers, the best way that we get work is to create fear and paranoia. I mean, if our clients are afraid that something's going to happen to them, whether it's a significant penalty or enforcement action, or even worse than that, they're going to go to jail, then that's where they're going to be most interested in getting our guidance. And that's very important to make sure that you're compliant, but I can become evangelical about the need to have good privacy and data security practices, not just to make sure that you're compliant with the law, but that it can really put you in a competitive advantage and not a disadvantage in the marketplace, because more and more consumers are not necessarily looking for businesses that they have assurance that they're going to keep their information secure, but they're going to avoid those companies that unfortunately get a reputation as not having appropriate data privacy and security practices. And I think that's true both for consumers and employees as well. So that's my sermon about data privacy. So as you'll see in the guide, we cover the whole landscape of privacy laws, and if sources of privacy law is in the United States, we've got constitutional law, but you should also know that the word privacy does not appear anywhere in the United States Constitution. It does appear in some state constitutions, but to the extent that constitutional law comes into play, there are Supreme Court cases that deal with what's a reasonable expectation of privacy, and a lot of that gets into search and seizure and issues related to government exercising their rights under the various amendments. Federal laws is what we're most concerned about or looking at in the United States. Relative to privacy. I'll talk about that in a minute. You've got state law, state tort law, invasion of privacy, and others that it's still very difficult to argue those cases because it's difficult to find harm in privacy torts. And then you've got state statutes, the most popular of which and most well known are the state data breach notification statutes that now every single state has. Okay, so here's our first member of the Privacy Hall of Fame. And so first I'd like to know, does anybody recognize this individual? Okay, who said that? Very good. That's Louis Dembitz Brandeis. And the reason that he's a member of the Privacy Hall of Fame is that he famously wrote this Harvard Law Review article with a classmate, Samuel Miller. And in that, he first articulated what was he penned as the right of the individual to be left alone. So this is in 1890. And so when he wrote this, the concern that Brandeis and others had relative to privacy was the terrible intrusion of Brownie cameras that were being used to take photographs and journalists writing things about individuals. That was an invasion of their privacy. So Brandeis went on then to become a Supreme Court justice and was involved in writing a number of very significant decisions relative to privacy. So that's the first member of our Privacy Hall of Fame, Louis Brandeis. So what data is valuable to others? More and more companies are not just concerned about keeping data private, but also they're looking to monetize data. So it could be valuable from that perspective of a business. But in most privacy laws, there is going to be a definition of what personal information is and what information needs to be protected. And here's just some examples. Social Security numbers, probably the easiest way for you to, if you wanted to become involved in identity theft, is to start, getting Social Security numbers. For that reason, it's also one of the biggest red flags that a company should make sure is that they never collect Social Security numbers unless they absolutely need to. And it's rare that you're ever going to need or want somebody's Social Security number. So if there's one thing here that you take away, if you're a business and you go back and you see that you are collecting and storing Social Security numbers, make sure that there's a real need for doing that. Otherwise, it's just a liability waiting to happen. So, talking about, Brandeis and his issue of data and or privacy, we live in a world where, you've got a thumb drive like this today where I could walk out of, Great Platte Moody with a significant number of, files and personal information, and also corporate information. It's not just personal data, but you've got confidential business information as well, intellectual property, and, jump on a plane and go to China. And so we live in a different world, obviously, than Brandeis did. But so that data is valuable not just to the employers and the businesses, but to individuals. Here's my next member of the Privacy Hall of Fame. Anybody recognize this person? Snowden, okay. Edward Snowden. It depends. Some people consider him a traitor. Some people consider him a hero. So it makes for interesting cocktail conversation. But so Snowden, here's a quote from Snowden: "Under observation, we act less free, which means we effectively are less free." And why is he important as a member of the Privacy Hall of Fame? So you're probably familiar with his acts to disclose the surveillance activities of the National Security Agency, particularly with the PRISM program. And his doing that has caused, and I'm not just saying this because this is my belief, but the Europeans have looked at the government surveillance here and the activities that Snowden disclosed as one of the reasons that the United States is deemed to have inadequate data security. And I'll explain to you why that's important in a minute. So Snowden and others who are concerned about, the privacy rights that individuals have, and the laws that have been created surrounding this, look at information that would be deemed personally identifiable. And so one of the common characteristics in all of these laws is the attempt to define the scope and boundary that companies and businesses or anyone collecting that information has relative to information that could be traced back to a particular individual. So if you don't have personally identifiable information that's de-identified or aggregate data, then you're probably not going to have as much of an issue. So the laws themselves are developed around the notion of trying to give individuals, I think, three main things. One is notice, that they should be given some disclosure as to exactly what information is collected about them and for what purpose. Access, that they may need to have appropriate access to their own data, whether it's to correct it, make sure it's accurate, and also some choice. Should they have, as an individual, have choice to determine how that data is being used? So, as I mentioned, we're living in a global economy now, and so there is going to be probably a need for you to share or collect data that might come from outside of the United States. And so because of that, we must be familiar with what those global privacy laws are. Many of you probably saw that last year a new law went into effect called the GDPR, the General Data Protection Regulation. How many of you, I just want to make sure, are familiar with the GDPR? Okay. most of you are now. I'd say 2 years ago, not very many people knew what it was. Even my 90-year-old, mother now, as it got closer to May 25th last year, said, Michael, now I think I understand what you do, because GDPR was on everybody's radar, and it looked like come May 25th, 2018, maybe the world was going to come to an end, because if you weren't compliant with these new European laws, you were going to be in trouble. But why is Europe so different than the United States? Europe has always taken the approach that privacy is a fundamental right. And data, personal data in Europe can't really be collected unless there's a specific reason and purpose, and the person has generally given consent to that, that use and collection of the data. That's generally been the approach in Europe for data privacy. Now, they also have, and not only under the GDPR that went into effect, but even the data directive that was in existence for 20 years before that, a specific prohibition about any data, personal information, leaving Europe and going to a country that's deemed to have inadequate data security. And the United States just happens to be one of those countries that is deemed to have inadequate data security. One of the reasons is because of the Edward Snowden revelations about our government being able to access that data. So for about 10 years, there was a program in place called the Safe Harbor Program that allowed businesses to transfer data to the U.S., and at least 8,000 businesses participated in it. It was a program where you would self-certify through the Department of Commerce as long as you indicated that you were going to follow particular practices, you were okay. And that was fine for many, many years until another member of our Privacy Hall of Fame that I'll show you in a minute felt that Facebook and Google and others were not participating adequately in the requirements of the Safe Harbor Program, and decided that he was going to have it challenged. So he did. The Safe Harbor Program went away, and we now have a program in its place called the Privacy Shield Program. I don't want to get into a lot more detail about that, but it is covered in your guide, and happy to answer any questions that you might have. But it is a program that's available currently for any business that wants to make sure that they comply with the core requirements that are in effect now under the GDPR. So this might be a little bit, difficult for, unless somebody's in the privacy field. Does anybody recognize who this individual is? Okay, so his name is Max Schrems. He is the person who is responsible for bringing down the Safe Harbor Program that I just mentioned to you. He was studying law at Santa Clara University in California in, I think, 2011, and somebody came in from Facebook and talked about, Facebook and what they did with the data, and he was very upset about it. And his life now has been kind of devoted to challenging Facebook and challenging other practices in relative data privacy. He's Austrian. His name is Max Schrems. He founded what's called the NOYB. I think it stands for None of Your Business. And they've been very active. So when he brought the first complaint in the Irish court to try to invalidate that Safe Harbor Program that I explained to you that, thousands of American businesses participated in, I think the majority of professionals who were practicing in the area thought this isn't going to happen. This is, he's lined up against Google and Facebook and others who were, fighting this. And he ended up getting it totally thrown out, so that businesses for some time did not know how they were going to qualify and be able to have that data transferred until the Department of Commerce and the European authorities were able to negotiate the new Privacy Shield program. So now MACS is very active again. Under the GDPR, there are significant fines that are available to the regulators. And you might have seen just a few weeks ago that there have been several already levied, but Google was just hit with one for $40 million. Okay, so it's not insignificant. Many of us were aware that the companies that were going to take the arrows in their back first would be the Googles and the Facebooks and the companies that, you know, have the deep pockets and are very active in this area. And so Max Schrems is right in there. Organizing. There are consumer organizations now in Europe that can bring class action lawsuits. So Max is a pretty significant member of the Privacy Hall of Fame. So back here in the U.S., what do we have to worry about as far as enforcement? We've got the grand poobah of privacy enforcement here is the Federal Trade Commission. And they have had about 100 cases in the past, I'd say, 10 years. Not a lot, but they typically enter into settlement agreements and consent decrees with companies that have been in violation of, for example, the Children's Online Privacy Protection Act and other cases. The Office of Civil Rights deals specifically with enforcing HIPAA. State attorneys general get involved in some respect relative to, you know, data breach claims. And then you have private lawyers. And there hasn't been a lot of activity because a lot of these laws do not have a private right of action. So as you'll see in the book, we really here in the U.S. have a patchwork of laws. It's kind of what I call the alphabet soup of federal privacy law. You've got HIPAA, you've got FERPA, COPA. I'm not going to spend time going through each of these. Again, the guide gives you a nice little snapshot description of each of the federal laws and what they cover. But just to make a distinction between the United States and Europe, so Europe, with the GDPR, has a very broad omnibus law that covers everything. One big comprehensive privacy law. Here in the U.S., we don't. Here in the U.S., it's more of an approach. You can pretty much do anything you want with data as long as you don't encounter a law that prevents you from doing it. You can monetize it, you can sell it, you can share it, but just make sure there's not a law preventing. So it's a lot more, you know, free enterprise-like in terms of what you can do. But we do take a sectoral approach, and that's why we're going to have Mark and Jesse here be able to answer questions that you might have about, healthcare and employment law. George Amines, who's not here today, for some reason he thought that the drive from St. Cloud to Minneapolis because of the snow would be a problem. That was yesterday. I think today's a little bit better. But George is available for those of you that have specific questions regarding financial institutions and Graham Leach Bliley. So we've got a sectoral approach by industry and sector, and then also by type of information. You've got COPA dealing with information from children. You've got the TCPA that Amanda's going to talk to you briefly about. That is very significant because it does have a private right of action. You've got commercial email. You've got student education records that are covered by FERPA. And then you also have issues, for example, in the workplace, that are specific to, where the data is located. So just, this morning I'm not going to do a deep dive into the California Consumer Privacy Act, but we are going to have another webinar on that specifically. And so if you sign up on the sheet, we'll make sure that you're invited to that seminar that's just going to be talking about the CCPA. And as we get closer to January 1st, 2020, it's going to be more and more important for you to be focused on what you may have to do to be prepared for that. So we do cover the GDPR in this guide, and the guide from last year became effective May 25th, 2018. The CCPA was passed June of last year, goes into effect January of 2020. Washington State is now considering a law that would be much more like the GDPR and give individuals control over their personal data. I prefer not to spend too much time talking about proposed legislation or bills because there's always something to talk about until it actually becomes a law. So we'll keep you apprised if and when the Washington State bill ever becomes enacted. This is always ever changing. So next week there's going to be a hearing at the Senate on what they're calling the policy principles for a federal data privacy framework in the United States. So I've been doing this for a long time, and I can tell you for the past 10 years, there's been a proposed federal data breach notification law discussed and has never gotten enacted. So once again, I'm very interested, and I will listen to this hearing, and I've got a copy, and you can certainly read a copy of this, a wonderful report that was prepared by the General Accounting Office that goes into a great argument as to why there should be one federal law dealing with privacy similar to what's happening in Europe and giving the FTC much more enforcement powers. This is something that continually is brought up and discussed. And so good question with today's Congress, are we going to see a new federal law in 2019? I'd say probably not, but, things can change. Okay, so here's another individual. Anybody know who this individual is? Okay, so his name is, first of all, I'll tell you his famously statement, I just think the data use by these companies is out of control. And his name is Alistair McTaggart. He's a very affluent California real estate developer. And this might sound like a joke, but this is it maybe has become almost a myth, but you can read a wonderful description of how Alistair McTaggart has really changed what we're looking at as far as privacy law in the United States by how he went about doing this. So it was August of 2017 that he walked into a bar and met a former employee of Google and a former employee of the CIA, and the three of them started talking about privacy. And the former Google employee told him things that horrified McTaggart about how Google was using his data that he wasn't even aware of. After that cocktail conversation, he started to fund a consumer effort in California to raise an initiative. In California, they have what's called initiative and referendum. If you get 600,000 names on your indicating that they want to support the initiative, it will appear on the November ballot, and the Californians can vote for it. So back in 2017, people were aware that this was happening, but really didn't pay much attention to it, including the technology companies thought, well, this isn't going to go anywhere. And then we had Cambridge Analytica and other issues that came up, and all of a sudden this effort took off, and they were very close to getting the enough names to have this appear on the November ballot. So because of that, legislators approached McTaggart and his group and said, we would rather pass a law. Literally in less than 8 days, the California legislature put this California Consumer Privacy Act, unanimously passed it. Governor Brown signed it in June of last year, and that's how we have the California Consumer Privacy Act. If they hadn't have passed that, McTaggart would have gone ahead and the initiative would have been probably voted on and approved by the California electorate, and it would have been much more stringent and worse for businesses than what it is. It's still kind of a mess, but and they're still working on trying to make amendments to it and fix it up. But it is something you have to be aware of. So if you weren't thinking about GDPR, because that's across the pond and we really don't do business in Europe and we don't have much personal information of European residents, you really need to be looking at the California Consumer Privacy Act, because California, I think it's the 5th largest economy in the world. There are not too many businesses that don't do some business in California, and it's got some pretty strong provisions in there that I'll just want to spend a couple of minutes, talking to you about. So the one thing about the CCPA is it is broader than the GDPR, and you'll see why in a minute. It gives Californians the right to prohibit data sharing, request access, deletion, and portability. Those are all similar concepts in the GDPR. So for those of you that have looked at GDPR and have implemented, mechanisms to try to comply with it, it will, put you in a better position than if you hadn't. But don't think because you're GDPR compliant that you're also going to be able to deal with the CCPA. So who is protected under the CCPA? Anyone who's a California resident, and it includes employees, patients, tenants, students, parents, and children. So if you look at the definition of the CCPA, it's not like the GDPR that deals with just, personally identifiable information of an individual, but it also identifies that households are protected too. So your energy usage data, for example, in your home may be protected data under the CCPA. There's a long list of information that's included. The one that I found very interesting, it includes olfactory information. So to the extent that smell, people are saying, is that smell-o-vision? Exactly what is that? So you can ask me many questions about the CCPA. I have to, a major disclaimer that a lot of people are still struggling with it and are looking for more guidance from the Attorney General's office, who are not too thrilled with the fact that they have to come up with regulations by July of next year. They're under-resourced. They're not exactly sure, how they're going to, meet that time frame. It seems like far enough away, but it's a real struggle for them. So who has to comply with this new law? If you're a business and you have gross revenues of $25 million, if you collect personal information of 50,000 or more California residents, households, or devices annually, or if 50% or more of your revenue is derived from selling California residents, personal information. So if you do any of those, you don't have to do all three, any one of those, you're covered under the CCPA. One of the things that McTaggart was most concerned about with the CCPA was that he didn't like the idea that his data was being sold, okay, or that was shared without his. If he went to Spotify, he didn't like the idea that 140 other companies were also being able to look at and share that data. So one of the things that CCPA does very, very clearly, and this is not in the GDPR, is that if you are selling, and you have to look at this definition of selling, then you've got some specific requirements. For example, in your privacy policy, you have to give the person the opportunity to click on a button that says, do not sell my data. Got to be just like that, do not sell my data. So you have to make sure that you are complying with the restrictions on the sale of data. And for those of you who are lawyers, it's a pretty broad definition, because at the end it says it's shared with any or other valuable consideration that's given for the sharing of that information. From a legal standpoint, getting consideration can be very nominal. It doesn't have to be a lot. So some people are thinking that you need to be really clear in your agreements that you have with parties where you're sharing that data, that you are not doing it for any consideration, just to kind of make sure that you're complying. So here's, again, showing you that to comply, you have to have that do not sell my personal information link on your privacy policy. That's right in the statute. So the reason this is getting a lot of attention too is that now there's some penalties for your noncompliance. The Attorney General's office can bring actions against you for any noncompliance under the CCPA, and if it's intentional, it could be $7,500 per intentional violation. There's still some question as to, is that per incident, or is it how many times, how many people, that might have applied to. But so general noncompliance will be enforced by the California Attorney General. But the area that you should be concerned about is there is a private right of action now. Again, remember I mentioned there's very few privacy laws that have a private right of action. They're mostly you have to be concerned about the enforcement by government agencies. Under the CCPA, there's a private right of action if you have a data breach and you're a business and you didn't have reasonable security procedures in place, that you could be liable for up to $750 per incident per consumer. So you can see how those dollars can quickly mount. And this is where lawyers right now, could be class action lawsuits brought against, companies for their failure to comply with that data breach. We don't have anything like that anywhere in the U.S. right now, where you have that kind of significant penalty. So this person, anybody recognize who he is? And why am I showing him? Except for that we are finally going to get the report I heard this week, but that's not why I'm showing him, to you. This is Robert Mueller, and you'll see why I'm showing him to you in a second, because here he was the former director of the FBI, and at that time he said there are only two types of companies, those that have been hacked and those that will be. And even if they're converging into one category, companies that have been hacked and will be hacked again. And that's very true. I mean, I do a fair amount of my work doing data breach. We like to refer them as data incident counseling, because we hope that it's not a data breach that requires notification under the various statutes. But there was Robert Mueller wearing a different hat as the former director of the FBI, cautioning businesses to make sure, and I think he'd be saying that even more now that we've got the CCPA adding those significant penalties. So again, there's hopefully going to be some cleanup done by the Attorney General's office, but right now employees are included within the definition, which was kind of a surprise to everyone, because no one thought, and I don't think, I've heard McTaggart speak, he really wasn't particularly concerned about employees having additional rights. He was much more focused on consumers. But right now, the way the Act is written, an employee can actually demand and request their personal information and their records under the CCPA. So we're hoping that we're going to see some regulations, and maybe they'll remove it, maybe there'll be an amendment. So the one thing about the law is it can be amended. If the initiative had been passed, that's it. Initiatives can't be amended. You have to live with it. So again, I already mentioned the differences between the GDPR and the CCPA. The biggest difference is that information is much broader in how it's defined under the CCPA than it is under the GDPR. And you need to be concerned, for the significant fines. As I mentioned, under GDPR, it's 4% of your revenue or 20 million euro. You've got class action lawsuits already possible under the GDPR, and the CCPA with their private right of action clearly is something to be concerned about. So I think I've covered this already. We're waiting for the Attorney General's office to come up with some more guidance and regulations and clean up a lot of the things that are in the CCPA. In the meantime, what you should be doing, and you should be doing this under your GDPR compliance, and as business that wants to be as proactive as you can to make sure you've got appropriate data privacy and security systems in place, is do some data mapping, do an inventory, make sure that you know what data you have and where it's stored. Do you have data, personal information of European residents? Do you have information of California residents? And if you do, how are you going to comply? Look at your privacy policies and update them, as necessary both to comply with the GDPR and the CCPA. Some businesses have taken the approach, they're going to look at California as almost a separate country, and let's have our policies just dealing with California. Other companies have said, no, we want to treat everybody the same. So whether you live in Oklahoma or Tennessee, you're still going to get the benefits that a California resident might have. Look at your vendor agreements. Make sure that if there's any liability that you need to pass down to them, that you do. And you've got to have appropriate systems in place. When those data access requests come in under the GDPR, you have 30 days to respond. Under the CCPA, you have 45 days. So you've got to have an appropriate, system and mechanism. Who's going to be getting those requests? How are they going to be handled? Data security programs. If you want to avoid that data breach notification issue, and not just notification or a compliance issue in the CCPA, have reasonable data privacy and security in effect. So I've got just two more Privacy Hall of Fame, and then I'm going to turn it over to the panel here. Okay, anybody recognize this individual? Okay, he might be one of the people that's most responsible for why we live in the world we live in today. This is a quote that he's saying today, but not at the time. What could happen if we give people privacy and we give people control of their data? This is the person who invented the World Wide Web. His name is Tim Berners-Lee, and he is very much concerned today about what's happening and is involved in the World Wide Web Consortium and trying to create more reasonable approaches to how we can get more control over the use and sharing of our data. And then the person who might be, also very responsible for why we're living in the world we live in today as far as privacy goes. I think this person's probably, anybody know who he is? Mark Zuckerberg. So he's having some difficult times these days because of the privacy issues. And he said, by giving people the power to share, we're making the world more transparent. So, we all kind of entered into this bargain with the internet and with Facebook. If you, are on, social media, you probably enjoy using it, and you don't have to pay a lot for it. The question is, should we be paying a fee for it? And would that, affect Mark Zuckerberg's business and others' businesses? But so now what I'd like to do is turn it over. First of all, are there any questions before we start getting some the comments from our panel on the different areas that, yes? Have there been any criteria, any period Not that I'm aware of, but I will say this, that I had mentioned that in my, 10, 15 years of following the federal efforts to try to create a federal law in this area, and then there would be questions about preemption of all the state laws, like the state data breach notification laws. Because of the angst that the businesses in the Silicon Valley are feeling about this California law, there's a lot of attention now being given to a federal law, and if they did pass it, this whole California law might go away. But who knows? Your guess is as good as mine. But from a constitutional, standpoint, I don't think so. And more states like Washington are now kind of jumping in, and there may be other states. So California has always been kind of ahead of the game in privacy. They were the first state to pass a state data breach notification law. It's because of California that we have all those, terrible privacy policies that lawyers write and nobody reads. But that was because of California that we have those privacy policies in effect. Yeah. No. No. And in fact, what? Repeat the question. Oh, I'm sorry for the webinar. The question is whether or not there was any involvement in this California rush to get this act passed whether technology companies participated in that effort. And the answer is no. In fact, there were just a handful of legislators that got together with McTaggart, and it was almost not extortion, but the deal was if you're going to make any changes, we're going to walk away because, and they can still come back if there are too much mending that goes on, and they, for example, take away the private right of action. McTaggart, they've got enough signatures, they'll just put it on the next ballot. So, no, it was pretty much a rush to get it done. So.
We also have a question from online that says, for CCPA purposes, does the $25 million threshold include the revenues of a parent company for a wholly owned subsidiary?
The answer is yes, as far as we know today, but that's a legitimate question. There's a lot of questions about the coverage, but that's the way most people are looking at it right now. And it doesn't have to be just money that's on revenue generated in California. Yes. No, it's any data that you have, and in fact, well, that's a good question because that causes first of all, the question is under the GDPR, there's a need to do some data mapping and inventory, and do you need to go back and see what data you have pre-May 25th? And the answer is yes, you do, because it's as long as you still have that data. That data is sitting there and is a potential risk. So one of the things that the GDPR as a principle has is called data minimization, and that's been true for even the directive before GDPR. You should only store data that you absolutely need. I mean, I've been kind of horrified when we do the kind of data inventory. We find out, businesses have customer data that's over 15 years old. There's no value to that data. That's data that's just sitting there as a potential risk and liability. But that raises another interesting point. Under the CCPA doesn't go into effect until January 1st, 2020, and it actually won't be enforced until July 1st, 2020, or sooner, because that's the date that the Attorney General's office has been given to come up with regulations. And so, for example, they're promising there are going to be regulations as to how to deal with requests from employees, or how do you verify somebody who's requesting, access or deletion to their data. So we're waiting for that. But the law, as it's currently written, has a 12-month look back. So what we're suggesting is that you actually have any data that you have today going back to January 1st of 2019, that data is also exposed and is at risk to comply with this CCPA. So your data mapping, really has to be laser focused on all of the data that you have. And here's the thing where, as lawyers, we love to tell our clients, this is what you need to do. I think it's really important to have that conversation with the IT folk, because the IT department, they're the ones that really put the systems and the procedures together, and they have to budget for this. The worst thing as a former in-house attorney is to go into the IT group and say, oh, by the way, we have to do this. And they look at you and say, where's the money coming from? Where are the people coming from? So that's a conversation from a very practical standpoint that should be had, in your businesses. It's not just the legal, determination. It's the IT people that are involved. So we're ready to hear from our experts now. I'd like to first start with Jesse. Jesse's a member of our healthcare practice group. And Jesse, if you can just talk about, what you think are the most significant privacy risks that a business faces today in the healthcare industry.
Sure. Well, it's a great question. And before I start, I'd just kind of like to get a sense, how many folks in the room work in healthcare? Could you just kind of raise your hand if you're touching healthcare? Okay, a fair amount. Well, that's terrific. So the slide here is obviously a very high-level list of some of the rules that are relevant to healthcare providers. And this list is just kind of the starting point. And I think it's a good way of answering Mike's question, because if you're a healthcare provider or if you're a company that's touching healthcare by supporting it, these kinds of rules all are going to be pertinent to your organization's compliance. So the biggest risk, I'd say, is also the biggest opportunity, and that's web-based, app-based, mobile device-based healthcare. All of the insurance programs in the U.S., starting with the Medicare program, which typically sets payment policy for commercial insurance, are really trying to encourage providers and encourage health plans to pay for and make healthcare available remotely. And that's because it's very expensive to build hospitals. It's very expensive to build institutional facilities to take care of people. It's often very cost prohibitive for providers to go out to rural or medically underserved communities and try to set up a clinic, or to send their physicians or nurse practitioners out traveling around to see patients. And policymakers, regulators, they recognize that. And they're also aware of all this wonderful technology that we have. And what they've kind of done is said, okay, let's see if there's a way that we can use our phones, we can use our computers to try to deliver health care remotely. And this goes back a good 10 years or so, where you've started to see providers and companies that support providers delivering care remotely. And that's terrific for patients. It's uniformly a way that lowers the cost of health care and expands access to health care, and those are probably the two most important goals in health care policymaking these days. The challenge, though, of course, is that when you have all of this data moving around from point A to point B, it raises the specter of the information going to the wrong place. I'm sure we all can all relate to sending an email to the wrong person, hitting reply all on an email, typing something in your text messages that gets changed with autocorrect. All of those things happen in healthcare too, and when those kinds of mistakes happen, the information can go to the wrong individual, for instance, which is a problem in a variety of ways. When companies who aren't driven by healthcare compliance decide to get into healthcare as a way of, being good entrepreneurs, they sometimes are not going to have the same level of familiarity with the rules you see on a slide like this. They're not going to know, for instance, about how you have to comply with state healthcare law and HIPAA. It's not sufficient just to comply with HIPAA. If you have a breach involving patients and you do business in 50 states, that means that you need to think not only about what HIPAA has to say about federal breach reporting, but you also have to think about what each of those 50 states have to say with respect to breach reporting. And many of those state laws are going to be more stringent, more rigorous than what HIPAA requires. So I think really it's this issue of trying to bridge the gap between needing to comply with all of these rules and regulations, doing so in a way that doesn't make web-based and device-based healthcare delivery more expensive than it needs to be, because obviously that policy is really pushing us towards delivering care in that fashion.
So I want to make sure you all know we're getting close. Unfortunately, I talked for longer than I should have perhaps, but closer to the 10 a.m. We're going to stick around to be able to answer any questions you might have. So I want to move on and let Mark from our employment area talk. And maybe, Mark, you talk about one thing that the businesses might be interested in knowing about is how do you deal with employees that are doing things online and taking care of off-duty conduct, and other issues that you think that are particularly significant for businesses in the employment context.
Yeah, thanks, Mike. So monitoring employees' activities online, whether it's on employer systems or on their personal devices or Facebook pages and other social media sites, is an important and broad issue in employment law. And on the one hand, employers tend to overlook sometimes the fact that they have, even with off-duty or personal social media conduct or activity of employees, employers may have liability. So, for example, if an employee or two employees are involved in some kind of potentially harassing behavior, maybe sexual or other types of harassment online, even if it's on their personal social media, that may come to be a liability for an employer, particularly the way that would become of concern to an employer is if a report is made to the employer, and one employee says, you know, this person is harassing me online. The employer does not at that point have the viable option to say, well, that's not my problem, that's not our site. That now is a workplace problem. It's been brought to you, it involves two employees. So that doesn't necessarily mean that you have a duty to monitor people's online activities on their personal social media. In fact, there are significant risks with doing that. But things that you become aware of may lead to, as an employer, may lead to liability. And that's an important piece for employers to remember. And then other things that can happen online with employees, even on their personal social media or other personal online activities, is that they are identified as an employee of your company, either because they have a picture of themselves wearing your logo somehow, or they say, I work at such and such company and this and that is going on. And you know, there's a whole wide range of online conduct, right? Not all of which you want to be associated with. And so that may be of interest. Your policies can cover that. And policy making becomes an important part of this, where you're balancing both, on the one hand, these potential duties or liabilities of an employer against the rights of an employer to monitor. And the key piece of that, particularly from an employment perspective, is you need to be talking to employees in advance in your policies about what is the extent of their reasonable expectation of privacy. Because at least from a common law perspective, that's going to be the key as to whether an employee might have a claim against you for invasion of privacy.
So I just want to take this opportunity to let you all know that we do have another legal guide that we do with DEED, and it's called the Legal Guide to Social Media in the Workplace. And it gets into a lot more detail about, the issues that Mark just raised. We actually have copies of the guide in the back of the room. It's also available. You can download it from our website or from the DEED website as well if you want a digital version. So, again, I welcome questions, but before we conclude with the panel, does anybody know there is another privacy law that exists right now where there is a private right of action? The CCPA is coming along. Anybody know which law that might be? Okay, I'm going to have Amanda McAllister on our panel talk to you a little bit about it, because you've got all these laws where you only have to worry about the FTC or a government agency. There is a law that has been very lucrative to many plaintiffs' lawyers, and it's the Telephone Consumer Protection Act. And I'll let Amanda, in a couple of minutes explain to you why it's one that you probably should put at the very top of your list if you're a business that engages at all in marketing using text messages or robocalls. So, Amanda?
Yeah, so the Telephone Consumer Protection Act, or the TCPA, does have a private right of action. The TCPA restricts the use of automated telephone equipment, such as automatic dialing systems, artificial or pre-recorded messages, and text messages and fax machines. So this is very different than one of your employees just picking up the phone and manually dialing one of your customers. The TCA is very complicated. It was enacted in 1992, and as we all know, communication technologies have advanced pretty rapidly since then. So the various requirements under the TCPA are going to depend on the content of the call, whether it's marketing, informational, or both, as well as what the recipient line is, whether it's a landline or a cell phone. And all the different iterations of that may have different requirements for the level of consent that's necessary. Further, the TCPA is a strict liability statute, and its damages range from $500 to $1,500 per violation. So you can imagine how high these damages get if your business is regularly engaged in the use of automated calls. Further, as Mike alluded to, the TCPA is one of the most filed lawsuits in the country, and it's more often than not filed as a class action. So these damages can really become astronomical for non-compliant businesses.
Okay, yeah, go ahead.
I think it applies. I think it also covers calls.
Yeah, so the question is whether those that are called that have registered on the do not call list that's been put together by the FTC, and
Yes.
the answer is yes.
Yes, that's correct.
That is correct.
It also requires that businesses have their own internal do not call list that they have to comply with when a consumer specifically states they don't want to receive automated calls.
Yeah, you know, and more often than not, a lot of these cases do settle, and you don't hear about them because it's very easy to prove. The calls or text messages were made, there wasn't prior written consent or other consent requirements were not met. So I know there's some lawyers, and that's all they do is TCPA lawsuits, and they have homes all over the world. Adam, do you have a question?
Excuse me. I have some. Has change in the regulatory environment a year that has impacted their cell phones? The reason I ask is, as a consumer, I've noticed a dramatic uptick and marketing calls, robocalls, and things. And I've had my name on the list for not all this forever. Has regulation been relaxed recently, or things of that nature?
Well, I'll let Amanda chime in as well, but there was a big case early last year dealing with, the definition of an ATDS, and also seemed to be making it more business friendly, I would say. And then there's a lot of decisions around the country dealing with this situation. So there's a lot of split courts. There's some question that the Supreme Court might get involved. The other thing is that there's a new chair of the FCC who has also did not like any of the, these laws and regulations. And, we've been kind of waiting to see. They haven't, repealed them yet, so they're still in place. But as far as I also get the same thing. I get those cell phone, we understand that your back is bothering you and we'd like to, send you this thing, you're entitled to it. And yeah, it's really bothersome. And so, but it does come under kind of the privacy, rules. Jennifer, do you want to say something? Yeah. That's right. Yeah. So they might be in violation, but trying to find them. My wife comes home sometimes and she said, "Are you talking to that person who's not really from Microsoft that's trying to give you support?" And most people hang up. I really get interested in talking to them and telling them I'm going to report them to, but they disappear and you don't. Did you want to add anything to? Or?
Yeah, just that we are expecting more guidance from the FCC sometime this year that we anticipate is going to restrict some of the rights under the TCPA.
One follow-up question. Is anything within that pending regulation that you see going to put restrictions on the ability to use technology there any sort of, recognizing sort of a technology issue and a legal issue?
Yeah. Yeah. Well, one of the problems with all of these laws, too, is they tend to be technology agnostic, and maybe for good reason. It's really hard because once you start being prescriptive about a particular technology, in a year it doesn't even exist anymore. And so, you know, it's sort of, you know, what do you do? How do you deal with technology issues and the law? It's always been a problem that we've had to deal with. Any other questions? Yes.
The general question on limitation of privacy. We have a computer company. I'm not going to find a European. Here's an example. One company has like home security deals. Where you were not.
Yeah.
What's the limitation? Now, they have to get the agreement. What's the limitation on it?
So the laws, and there's actually a lot of, you know, misunderstanding about this. And there were so many webinars and people talking about the GDPR and what it covers and what it doesn't cover. And it doesn't cover all European citizens. I mean, what it is limited to is when you collect information, personal information of a European resident, and they're a resident at the time that you collect the information. So if you happen to be in France, you're technically a resident in Europe at that time. When that information is collected about you at that time, it would apply. But it's real important to know that it is limited to information, personal information, of a European residence that's collected at the time. Now, it's easy for me to say that to you, but you know, we live in a world today where, because of the GDPR, all companies and vendors are challenged to look at contracts that they're being asked to sign to comply with the GDPR. And I think you have to be really careful about agreeing to, you know, obligations that, you know, may or may not be appropriate. But that becomes a matter of contract. You know, that's not that the GDPR has said that you as a vendor have, you want to continue to do business with a company, and they're saying, we're sorry, but you're going to have to sign this agreement. The one thing that I always challenge my clients to do is first ask the question, are you going to be collecting information of a European resident, and maybe tell the company you're dealing with, don't give us any of that information. We're not going to comply with the GDPR, and furthermore, don't share that information with us because we don't want to be, you know, liable for that. Are there any other questions from the online community?
We have one question. How do privacy laws protect the individuals on the dark web?
On the dark web? Well, not very well. I mean, you know, I don't know if any of you have heard, there's a local forensics person named Mark Lanterman who's done presentations here, and he will actually take you to the deep dark web where you can purchase credit cards as, you know, focused on, you want somebody who lives in the Minnetonka area, and you'll be able to buy that credit card. So, you know, I think that with that, you just have to be really diligent about your own privacy, checking your credit reports. You know, just last week I found out I have 5 telephones on one account where my kids and my daughter-in-law are on the AT&T account, and all of a sudden 3 of the phone numbers weren't working, and we called support, and they said, well, are you in Philadelphia? I said, no. They said, well, because you're using a Philadelphia cell tower. I said, no, because my phone was still working. They said, and then they found out that somebody had managed to get my credentials, saw that I was entitled to 3 upgrades. So in Philadelphia, 3 iPhones were bought, and they were off and running. And in the meantime, you know, our account was down. We couldn't use our account, and it was a mess. But so this stuff happens. I immediately, and I would suggest everybody check your credit, because if they were able to access my AT&T account, they could probably access other accounts as well. And I didn't want to have to, you know, deal with the deep dark web. I mean, if you want to buy, you know, illicit credit cards, then you probably, you know, might be able to figure out a way to do that. But any other questions? Well, again, I want to thank you all for coming. We're right at the 10 o'clock hour, and we're going to stick around if you have any questions. And we will be doing a webinar, as I mentioned, on just the California law. If you sign up, we'll make sure you get the invitation. If you don't sign up, we consider privacy very important, and we're not going to be sending you or soliciting you unless you give us your permission and sign up for that. So thank you all for coming, and thank you for those of you that are online as well.